use them wisely. So, so non-compete agreements are, most people when they think of non-compete agreements, uh, they think of actually what are multiple types of agreements. One is a contractual agreement to not compete with your former employer, usually by working for a competitive company or in a competitive industry. Uh, there's also such thing as a non-solicitation agreement, which some people write into non-compete agreements as a different clause, but some courts treat them as separate. Those are agreements to not solicit away the customers of your former employer or to solicit away their employees, so your coworkers or your colleagues. And then there's confidentiality and non-disclosure agreements. Those are agreements to keep trade secrets of the employer, keep the employer's confidences, to not disclose certain information. You're also bound, there are trade secret laws, and both federal and state trade secret laws, but usually you want to write into a good employment agreement. Additional agreements to not disclose trade secrets or intellectual property. And you also usually want to have an invention assignment agreement, which is an agreement that anything the employee makes or works on while in your employ belongs to you as the employer. You know, and those are not, none of those things are actually technically non-compete agreements, but they're important as far as protecting your business, and they're an important way to capture the business needs that non-competes usually are addressing. So why does a company have a non-compete agreement? Well, you'll have a non-compete agreement usually because there are certain key employees. So, usually they're for executives, for key inventors and scientists, and key salespeople. You don't want to have a strict technical non-compete agreement for every employee because they're not going to be enforceable. If you're a receptionist, you're not going to be able to enforce a non-compete against them. You know? It's unlikely that your receptionist is going to know your trade secrets or is going to have some special skills that is going to warrant restricting your ability to get a job elsewhere. But the business reason for having non-competes, really, I think it's obvious, but it's, you've got a salesperson who's building a book of business, developing relationships with your clients, your customers. You don't want them to take that book of business. Or if you're inventing something, you're working on a secret project, you want to make sure that the person who's the only person that you've sourced and, to build this, whatever it is that you're building, that they can't quit in the middle, or they're not incentivized to quit in the middle and take the technology to the competitor, or just not finish the project, which is a Class C product. So those are, and executives, it's the same thing. CEOs, a lot of times will have board members, certain executives will have employment agreements that are not at will, and so usually you put non-compete in there because you're giving them extra benefits to not fire them, so you also don't want them to quit without justification. But as I said, they're not for everyone. So I'm just going to share with you my opinion on non-compete agreements. Most of the time, I think they're not worth the paper that they're written on. I think they're vastly overused by people, that people are much more concerned about them than they ought to be. I think they can be a useful tool for key employees and particular people if you are worried about protecting your business. And I definitely advise that you protect your business. But if you think that you can just keep all of your salespeople or all of your run-of-the-mill employees from quitting and going to your competitors with non-compete agreement, you're probably going to be disappointed. There are better ways to encourage employees to stay with you that are less litigious. One of the things I actually dislike having to advise on non-competes all the time, because especially with new businesses, people come and say, I've invented all this stuff and my business is so cool and so new, and I need to not let anybody in the whole world know about our secret stuff. And they want to paper it to death. And I would say that most of the time you're going to spend a lot of money on attorney's fees, or you're going to do it yourself, pulling the documents off the internet, and you're not going to be as protected as you think you are. So there's good ways to use non-competes. They can be useful for your business. But there's a lot of other business ways to get at what your problems are. So I always want to look at the situation, what you're trying to really achieve, before you start drafting up legal documents. The other thing is that employees kind of take them as being kind of hostile. because they are a little bit hostile. And so when you throw a bunch of legal documents in front of employees that you have to sign all of this, it can start the relationship off in not a good place. So you want to consider those things as well. With that being said, they can be useful. You guys are here to learn about them, so, and also to learn about when you can get around them. So that's what I'll tell you about. All right, so there's a lot of restrictions on non-competes, and I think the most important that you should be aware of, especially nowadays, is cross-border concerns. So in Illinois, non-competes are very difficult to enforce. So somebody could sign a non-compete here and then drive, 10 miles to the east, and it wouldn't be enforceable necessarily if they decide to get a new job. So you should be aware of that. They're also not enforceable in Oklahoma, our neighbor to the other side. They're not enforceable in California. And there's actually a bunch of states that are not enforceable, but those are ones that I would see coming up a lot in this area. You have to be careful when you draft these to try to make sure that Missouri law applies, but you should be aware that if an employee decides to become mobile and go to a competitor that's in another state, that you might not have as strong an enforcement as you thought you would. The terms of the non-compete they have to be reasonable. So the idea is that, yes, you're protecting the business and everybody has freedom of contract, but it's generally against public policy to prevent people from being able to work again in their professions. That's why non-competes are very enforceable in different states. And there's been more legislation over the last few years with the bad economy, even restricting this stuff even further because it's preventing people from getting jobs, particularly people who are in the banking industry. They were having a hard time getting jobs because of all these restrictive covenants. And so a bunch of states have passed new legislation preventing, really restricting the scope of these agreements. So if you want to have an enforceable non-compete agreement, you should be very specific about what it is you're restricting and why you're restricting it. You want to be reasonable as to scope of your restrictions. So you don't want to say, well, they can't solicit, especially if you're like a big company or you have a big database of customers, you can't say, well, you can never speak to every one of our customers ever again. That's probably going to be considered too broad. But you can say, well, you can't go and work for Acme Company's my direct competitor in this position for 2 years. You might be able to do that, or you might be able to say you can't solicit certain key employees, or you can't solicit customers with whom you've built a book of business over a period of time. So things like that are drafted narrowly to really get at the harm that you're looking to prevent. And it can't be forever. So I usually don't draft a non-compete for any longer than 2 years. That's about, I'd say just, there's not a hard and fast rule on that, but that's about average. Some people will go longer, but.
Are most of those industry specific and sort of niche specific as well as what those restrictions are?
Yes.
In terms of scope and time? And
yes, exactly. So instead of saying, you can't go get a job for anybody ever, which obviously would be overbroad, you'd say, okay, you're a salesperson, I'm a biotech company, and I work in, this particular technology, and you can't go work for any other biotech company in this particular technology in the Midwest or in Missouri, or, depending on how niche it is, you can even say the United States, for a period of 2 years, because we have some cutting edge technology that's patent pending or whatever.
Come on in.
All right.
He's not seeing this great. Sorry, thanks.
No, welcome.
Hello, I'm Alicia Dearn, and we're kind of talking about the restrictions that apply to non-competes here, just to get you up to speed. And actually, that's what I have to say about that. So earlier I was giving you my opinion on you don't want to overuse non-competes, and the reason is that you don't want to invite lawsuits because businesses have better money to spend than on lawyers and on lawsuits. And most of your agreements, if they're well drafted, are going to have attorney's fee provisions, which are going to shift the attorney's fees to whoever loses. They have to pay the other side. Well, if you draft something that's overbroad, guess who's going to have to pay for the employee's attorney's fees? So you want to make sure that what you're doing is very focused on what your business problem is and is addressing that issue. Courts have a lot of options if they think that a non-compete agreement is overbroad. Sometimes they'll just completely invalidate the entire employment agreement. They have the ability to do that. More often, they will revise the agreement into something that they feel is more reasonable or is enforceable. But you're betting that the judge is going to do that if you overplay your hand with a non-compete agreement, and can't be sure that the judge will do that. And you have to go through a lot of litigation to get there. And as I said, there's attorney's fees involved. You have to pay your attorney to get through it. And then there's the risk of shifting attorney's fees. And so I think so I would humbly offer the alternative. You use other business devices besides non-competes in order to safeguard your intellectual property, to safeguard your key employees, and to retain your key employees. Actually, that was my whole my whole presentation. So let me ask you, if you guys have questions.
What industry do you think has it the most? Do you think it's IT based? Do you think because I've seen it actually a lot in the food industry when it comes to like recipes and what have you, which is really interesting.
Right. I mean, anything that's going to involve any intellectual property, people are going to try to maintain some of that stuff. It's really hard to patent a recipe.
Right.
It's hard to patent clothes. So the fashion industry has it a lot. It's a lot easier to patent in hard technologies, but even still, Simon and I were just talking earlier about how the human genome couldn't be patented because it belongs to all humans. So if you're in DNA science, you might not be getting your patents either, even though you have cutting-edge scientists. So, but the answer to that is not necessarily non-competes. It really is invention assignment agreements and trade secret agreements to make sure that everything that the employee is working on belongs to you as the business owner, belongs to the business, and can't be taken away. And you can include injunctive relief and all kinds of stuff, and those are a lot easier to win if you have to litigate than saying the employee can't go work for somebody else. Maybe they can go work for somebody else, but everything we did for you stays with you.
Okay.
Geographically, are you finding that there's a sweet spot for how far people can go? I mean, if employers try to be more aggressive and stake out a larger geographical area, that those are failing, or have you found something that works in most states?
I will say that it is theoretically possible to have an enforceable nationwide non-compete agreement. But as you guys just walked in right after I talked about this. No, it's fine. There are cross-border concerns because non-compete agreements are not enforceable in a lot of states. Or they're enforceable under very strict conditions. For example, in Illinois, they're only enforceable if you pay extra consideration for the non-compete agreement, and there's also a bunch of other restrictions. If the employee goes to California, they're not enforceable at all. So even if the agreement says Missouri law, a California court will still hear it and say, sorry, it's against our public policy, and we're not going to enjoin this person. So you can get a judgment all you want from Missouri. It's going to be ignored in California. So usually I do not like to draft non-compete agreements that are nationwide, but it does depend on the industry.
Is enforcement more favorable for the employer if the employee tries to start their own business based on your book agreement? Or based on your secrets?
It can be. Again, it's a question of what's reasonable. So the employee is still allowed to engage in a profession, whether it's with another employer or whether it's starting their own business. So I think that there's sort of this instinct with judges and juries, when somebody goes and takes a big piece of business and starts their own business, that's not very fair, and so it usually results in it being a little bit harsher or more judgment on them. But as a purely technical matter of law, it doesn't make a difference. It only makes a difference if they were an owner or co-owner of your business. So for example, if somebody is a shareholder co-owner of your business and then breaks off and starts another business, non-competes are much more enforceable in those situations, even in states where they're not generally enforceable. And you've also got other claims for breach of fiduciary duties and stuff. So one of the things you might even consider is if you have somebody who is truly like a key scientist for your business, what you might want to consider giving equity. Although, to be honest, I avoid giving equity a lot of times in business. I'm of the business mind of you shouldn't share your business. You know, you can give profit sharing and stuff like that, but the more equity you give, the more dilute. You know, there's all kinds of other case problems, but it is a way to go about it.
How would you counsel a business that would approach you and say, I want to use this as a deterrent principle?
Can you repeat that?
Sure. Let's say I have, a business, I'm making widgets, and I have one key salesperson who's fantastic at selling widgets. And I know that this generally isn't going to be enforceable. What about the point of just saying, I just want this employee to think twice or 3 times before they go out and try to jump ship?
A lot of employers do it for that reason. And in Missouri, that's okay. I also practice in California, and in California, that's a tort. You can't do that there. But Missouri hasn't quite gone there yet, but I do see some other states going that direction. But sometimes it's good to just, depending on that employment relationship that you have with that employee, sometimes it's good to give them that warning, because a lot of people will abide by their agreements just as a matter of principle and never question whether it's enforceable or not. But if enough money is offered to somebody and you've got another big company trying to pull away the employee, and they say, their lawyers look at it and say, hey, it's not enforceable, then you're going to lose that benefit.
Did you cover customer contacts and
So
LinkedIn already?
non-solicitations.
Probably, yeah.
So non-solicitations are generally more enforceable than the non-competes where people can't go work for another business. And again, you want to tailor to contacts that employee is having. So you can say, you can't take the book of business that you developed here to another company. And you want to be careful about how that's drafted, but I routinely draft those, so particularly for salespeople. You also want to consider having non-solicitation of your employees. So you wouldn't want your salesperson leaving and taking a bunch of other salespeople with them to another company. So, and the non-solicitation of fellow employees are usually pretty enforceable. So those are good ones. And of course, if you guys ever if you're in a position of hiring somebody away, the upside of this, or the flip side of this, is that, because things are frequently not enforceable, you can get good talent and not have to necessarily be afraid of any covenants that they're under. But you should always have an attorney look at them and consider the risks and weigh the risks of potential litigation against the benefit of getting that employee. More questions?
So if you had a national corporation and you hired somebody in, let's say, California, but could you still have them sign a non-compete if you were in a state that had non-competes? So let's say you had, I'm from Massachusetts, but you're in Massachusetts, you hire somebody, you have them sign a non-compete, they go work in California. Yeah, it's not enforceable in California, but would that, if you hired them in California and then they went somewhere else?
Well, the employment laws that apply to the employee depend on where they're physically located.
Okay.
So if they're working in California, then those laws would apply, and if you had them sign it, not only would it be unenforceable, but you could get sued for it. But if you had them in California, you're going to relocate them to Massachusetts. And Massachusetts is one of the states where there's been a bunch of legislation lately, limiting these. So
they've been trying Yeah, the governor spent the current governor's behind it. I don't know how much the next governor is going to be behind that.
Right. So it'll be interesting to see. But I recently had a client who did that exact move and went from California to Massachusetts, and went from having an agreement where there was no non-compete to where there was. So you can't do that when you relocate people.
Okay, you cannot.
You can do that.
Oh, you can? Okay.
Yeah, it's just where, while he's working in California,
Yeah.
no non-compete. While he's working in Missouri, non-compete would be okay,
Yeah.
under Missouri law.
So what happens to all the old non-competes if they change the legislation? Do those become null and void?
Yeah, that's a good question. They're mostly going to be considered under the new laws.
Okay.
Even though it's sort of a post facto application of law,
Yep.
which is generally not allowed.
Yep.
Most of the time, the legislature is going to write in there that was their intent, or the court's gonna apply the new law.
Okay.
So, there might be some argument on that.
Okay.